Mediation when you're sued for debt. Brought to you by Kenneth Chabert at yourlegalleg.com. Your advantage if you're being sued by debt collectors. People being sued for debt will often find themselves going to mediation. This could be because the courts have a policy which requires every lawsuit to go to mediation, or that they require cases not above a certain dollar amount in dispute go to mediation. As courts have become more crowded over the years, mediation has become more and more popular. And since that trend is growing, mediation will probably also become more and more popular still with the courts. There are some special dangers for pro se debt defendants, though. First of all, what is mediation? Mediation is a negotiating session between the two or more, in more complicated litigation, parties. You get together and work things out, supposedly, with the help of a mediator who is supposed to be impartial. Any agreement that you reach is voluntary, which means that you don't have to agree to anything at all. You could end your mediation without settling. Of course, voluntary doesn't mean that you might not be afraid to keep litigating if you don't settle, so fear will exert pressure on you. Voluntary just means that you aren't legally compelled, forced, to settle at mediation. And if you don't settle, you go on to the next phase of the litigation, discovery or trial or whatever. The way mediation typically works is that the mediator will have you come to his or her office. You'll start in a bigger room, probably with the mediator, you, the debt collector's lawyer, possibly and really probably more than one lawyer for the debt collector, and a representative from the debt collector. Everybody necessary to make a final decision is supposed to be present or easily available. And when everybody's there, the mediator will usually make a speech about the wonders and value of mediation and his role in that. And then the plaintiff, that's the debt collector in these cases, usually makes a speech, usually to the effect that while they've got the goods on you and could easily win, in the spirit of compromise and out of the goodness of their flinty hearts, they're willing to settle, for a price, of course. Often they'll say a number they'd settle for, and this number, which is an offer, will be much higher than they would actually settle for if they're serious about the whole thing. For a while, negotiation books all said that you should give a number that wasn't much higher or lower than you'd take. But not all lawyers got that memo, whatever they might say about it. If they really won't come down from the number they give you at the first, substantially, then they're just using the mediation session to try to bully you into giving up. I wouldn't take that seriously. Anyway, then you might or might not make a speech. Your lawyer almost certainly would if you had one, and ultimately you or your lawyer would shoot back another number. Some mediators skip this step, though, and go straight to the private sessions. They don't have you make a counteroffer. Notice that the whole idea of mediation in this example seems to suggest that you will pay the debt collector something, and you will feel that pressure, the assumption. But you could say you don't want to pay anything, or if you have a counterclaim, you'd probably say that you wanted them to pay you. Just remember that the dance of mediation will involve both parties basically scoffing at each other at first. They'll be sure they could never lose. You'll say something equally confident, and behind the scenes, the mediator will probably be telling both of you that you probably will lose. After the speeches, the parties split up and go into different rooms. The mediator typically goes with the plaintiff, if the defendant has already made an offer. After that, the mediator shuttles back and forth between the parties, relaying offers and information as you try to work things out. In theory, everything that you say during mediation is confidential. That means that the mediator is not supposed to share things that you say when you're alone with him or her unless you tell him to. And also that the things that you said to the other party can't be used as evidence either. You'll probably have to sign an agreement about this at the beginning of the mediation session before it really starts. In reality, the things that you say will be known even if they aren't admissible as evidence. If you say something to the other side, they will obviously know what you said, and if they like it, they'll ask you about it in discovery so that they'll have it in admissible form. You can too, so pay attention to what they say. If you say it to the mediator almost certainly will not say it to the other side, but it will probably be transmitted through attitude. So, for example, if you tell the mediator that you have no money and no job and are surviving on a disability pension, the The mediator will probably tell you to settle, that you have nothing to lose, but he will also suggest to the other side, and very strongly if he believes you, that they're wasting their money by chasing you. So if they don't settle, they should just drop the case, or they should come way down on their offer. By the way, you're not under any kind of oath at mediation. Lawyers have very vague ethical obligations in this situation. I'm sure I wouldn't trust anything that they said as fact, really. And I'm not sure that you will have any obligation at all. Back to the point, though, if you do mention that you have money or assets, this too will be transmitted one way or the other. The mediation process is rigged against the debt defendant. To find out why and what you can do about it, go to my website and read the article called Preparing and Defending Mediation Pro Se When You're Sued for Debt. It's free. The link is in the notes to this video, and here's the URL. http://yourlegalagup.com/pages/mediation. This article will help you prepare to defend yourself in mediation. Protect what's yours and don't let the debt collectors rip you off. My site and materials can help. Go to yourlegalagup.com. Get my litigation manual and forums, or get the videos and defend yourself. You'll be glad that you did. You may not consider this video or anything I say in this or any video as legal advice. I cannot give you legal advice, but as a former lawyer, I do know the legal process and debt law very well. So use what I say as a source of information and apply your own judgment to your case. To get more help on fighting debt collectors and their lawsuits, go to yourlegalagup.com. Get my litigation manual and forums. If you appreciate this video, please take a second and like it, subscribe, and friend me, as these things will help others find my videos and begin to learn more about the debt litigation process. Defend yourself from the debt collectors on Facebook or YouTube, as these things help others find my videos and begin to learn more about the debt litigation process. Defend yourself from the debt collectors.